Good afternoon and welcome to WG University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. My name is Jeff Lockyer and today I'm presenting from our Philadelphia office, though my typical office is usually in Newcastle, Delaware, in addition to our Dover office. If you'd like to view this webinar again or see any of our other webinars, you can go to our website, www.wglaw.com. And there you'll find copies of this presentation and others under the WG University page. Also feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is entitled Defeating a Hoey Defense to Obtain a Termination of Workers' Compensation, Wage Loss Benefits in Delaware specifically. Let's get started. Now what we're basically going to be talking about here is an affirmative defense that the claimant will put on to try to defeat the employer's termination petition. But a little background is probably necessary to explain the Delaware system before the actual defense will make a lot of sense. So the structure is that you have the Delaware Workers' Compensation Act that governs workers' compensation in the state. That's the law of the land. The Department of Labor and Industry oversees workers' compensation matters. The Industrial Accident Board is essentially your trial level. There will be two board members to a case. They are not lawyers, but they are essentially your judge and jury. They're the finder of fact. You also have a hearing officer who is a lawyer and is there to essentially advise the board of legal rulings and anything that kind of deals with a more specific legal issue. They do not, however, rule on your case. There are situations you can stipulate to having a hearing officer specifically deal with both deciding your case and the legal issues by themselves, but you have to stipulate to that. Then if you have to appeal, you go up to the Superior Court. That's the main trial court in Delaware. They're going to hear anything in that court from a multi-million-dollar merger case to a capital murder case. They also have appellate jurisdiction over workers' comp. And then finally, if you appeal that level, you go up to the Supreme Court. Very few cases go to the Supreme Court, though some do. As far as benefits, this will help kind of understand what we're talking about today in more context. You have total disability benefits available in Delaware. That's wage loss for people that are completely out of work, totally disabled, or a few other reasons that we'll talk about. Partial disability is available, and you're probably familiar with that. That's when someone is working or has some loss of earning power, but not total. You also have permanency benefits, scarring, medical, death benefits. None of that is implicated today. They're just benefits that are available under the Delaware Act. A termination petition everyone calls it a termination petition in Delaware. However, it is technically called a petition for review. You're asking the board to review the wage loss benefits that someone is taking. It only applies to wage loss benefits. If you win a termination petition in Delaware, you're not going to eliminate permanency exposure, scarring, medical, just wage loss. If you're a Pennsylvania workers' comp person, you would probably call it a suspension or a modification petition. That's really what you're doing. You're trying to either cut off wage loss completely or reduce it to some lower partial rate. A big thing to remember is that you cannot stop benefits, wage loss, without a petition unless someone comes back to work. That's the only other way, but no unilateral cessation of benefits in Delaware. Need the termination petition. So what's the procedure for filing? It's a little different than some other places. You have to physically serve the claimant and their attorney. You run into problems with this. Claimants refusing service, counsel refusing to accept service on behalf of their client. But in the long run, it's more like a civil case where you do actually have to serve the parties and then be able to prove service. Once you get that back, you can file the petition with the IAB, including your proof of service. At that point, the board is going to assume payment of TTD. So if you're paying the person $600 a week in total disability, once the board has your petition, they'll call you if you're the carrier, and they'll say, we're picking up as of this date. At that point, you can stop paying, which is great. However, should you lose the petition, you pay back the board. If you win, you don't pay anything back. So there is a real plus to getting your petition filed as soon as you have the legal basis to do so. All right, so what do we need to file a termination petition in Delaware? It's a little different than some jurisdictions, and actually easier from a medical standpoint. So the medical burden and element you need to establish is that the claimant is not totally disabled. You could have a part-time sedentary duty release 3 hours a day. Technically, that's enough for a petition from a medical standpoint. But you do need medical evidence. Even if you see someone pushing a Buick, you're still going on surveillance. You still need some medical opinion stating the person is not totally disabled. Claimant, the second element is that the claimant has earning power. There are a variety of legal defenses, and then there's your more standard defense you can run into of somebody saying, sure, I can work in some level, some capacity, not what I could do before my injury, and I just don't have the skills to go out in the labor market and find another job. So that means I should still stay on total disability. So that happens all the time. The typical way it'll happen, you get a medical report, a DME, or a release from the claimant's doctor. They say light duty, great. You file the petition, because again, the board's going to pick up, so you don't want to wait. So you file it, and then you go get an earning power assessment from a vocational expert. They're going to look at the job market, come back with an earning power based on what that person's skills and their restrictions dictate. And that's what you're going to fight over. So that's your standard petition, where you're saying light duty restrictions, earning power that exceeds their pre-injury average weekly wage, and therefore benefits should be terminated. All right, so this is where our real topic of the day comes in. After we've just established everything we talked about in the last slide, the claimant can present a legal defense. And this isn't in addition to other standard defenses. They could disagree with your medicine and say, I'm actually medically totally disabled. Or they could disagree with your vocational expert and say, I don't have the skills for these jobs. Those are actually somewhat rare in Delaware. I wouldn't say rare, but less so than you see in other jurisdictions. What you do see are various legal challenges to terminations. The one is a Hoey defense, and it's not Hoey, like that's a bunch of Hoey. It's just a person's name who the case is based after. But in some ways, you could say that's the type of defense it is. The defense applies in a Delaware petition where you have a claimant that's been injured, that's out of work, but they stay technically employed with the time of injury employer. So that's very wordy, I agree, but what it means is if you're the employer and your employee gets injured and they haven't been back to work and you get a medical release, say light duty, and you file your petition, there's a good chance that employee, if they remain employed by you, the employer, are going to present a Hoey defense. And we're going to talk about how you deal with that as a carrier or an employer. All right, so what's the impact of the defense? Why is it important? Well, it's important because if the claimant can establish a Hoey defense, it defeats your termination petition. And you might have established everything, that they can work full duty or with almost full duty, and they have earning power, considerable earning power. They're going to say, well, I don't have to look in the legal labor market because I'm still your employee. I have an expectation I should be able to come back to work. So it's significant, and it can be the biggest hurdle of the several hurdles you need to jump over to get a termination in Delaware. All right, so the initial case is actually, I think the court made the right decision. It's just more a matter of how it's been applied recently and over the years to be a bit of a broader defense than I think the court ever intended it to be. In the initial case, Mrs. Hoey was injured, given restrictions, and then repeatedly told by her employer that there was modified duty available and that she would be returned to work. Basically, they said, we're just looking for the right job. We have something for you. She was union and a long-term employee, so she's not the kind of person, and also had a high rate from her years of service. Not the type of thing where you can just walk out the door and you're going to get that $20 an hour, which at the time was very high when this case came out. So it was a situation where she was a long-term employee, and there was a reason for her to believe that she was going to find some other light duty with her employer. The employer then went ahead and tried to terminate the wage loss benefits by filing a petition, and they didn't offer her a modified duty job. So the court ultimately held that because Mrs. Hoey remained employed and she was induced by the employer by virtue of the employer's conduct, that she had a reasonable expectation of continued employment. She did not have to look in the labor market and could stay on TTD. And why do I think this is a good decision? It's not good in the sense that it helps the employer, but there are enough facts here that you can see where the court is logically making a conclusion. They're basically telling the employer in this case, you can't have it both ways. If you're going to tell her to not look for jobs because you're getting her one, you can't then say, hey, she's not out there looking for jobs in the labor market, cut off her TTD. Okay, so we know where we stand there. Why is this a problem? Because with a broad application of this rule, how are you supposed to terminate an injured employee's TTD if they're still on your books? And this happens a lot. There are a lot of employees who are injured, have not been back to work for a very long time, but are still technically employed. They don't get a termination letter, etc. So it's a situation that comes up frequently. And at a big company, you can think someone's terminated, and they're actually not. They may still be on an active duty list. So how has it become more of a problem as I see it? Claimants attorneys are basically trying to broaden the rule to say that the Hoey defense applies to anyone that stays employed. So look, my client's employed, therefore you can't terminate their benefits. And that would obviously be a disaster. In my view, they're ignoring what the court really laid out as the elements to meet the defense, which is you need a reasonable expectation of continued employment. And you also need to be induced by something the employer has done. They're basically, claimant's bar wants to just kind of remove that, get right to the heart of the situation of making it a matter of technical employment. So what do we do to rebut the defense? What we do is bring in employer fact witnesses. And you need to set this up from the outset. So that involves communication with the employer, risk management, the TPA or carrier, and the defense attorney. Everyone needs to know what the employee's situation is. Are they union? Have they been provided a termination notice? Have they been advised there's no light duty for them? Are they still collecting health benefits with the employer? Anything that shows attachment to the company is going to need to be discussed early on if you're going to properly rebut the defense later. All right, so the first thing you talk about is that there was no inducement. So you need to have a conversation amongst everybody involved in the claim management as to whether that occurred. Were there conversations with the claimant where they may have been led to believe that there could be light duty for them? Or was the opposite true? All right, so that's also what you want to flesh out. You could say, I sat down and told her we don't have light duty, or we wrote her a letter, or it's in the handbook, etc. But these are all, this is something you need to establish through factual investigation. The next element is whether there's a reasonable expectation of continued employment in the claimant. So how do we establish this? And I'll give you an example. You have someone who works in retail, a retail clothing store. Their job is basically to move merchandise throughout the store, as well as assist customers. So it's a job where you're never going to be able to sit down. You're going to be moving all day long. And we've had a similar case. So the person had a knee injury. and in their view, and in their doctor's views, was never going to be able to get back to that pre-injury job of being on their feet all day long. Just was not feasible, was never going to happen. Permanent restrictions, in the opinion of the claimant and her doctor. All right, so she was aware through acknowledging it in testimony and through conversation with the insured that they had notified her of this. Look, we don't do light duty. It's not that kind of store. We will never have light duty for you. And the claimant had to admit it during the hearing because there was paperwork to back it up. So is it reasonable to say, well, I didn't look for a job because I expected I'd continue my employment, even though I know physically they will never have a job for me? And that's just, that is unreasonable. And we had the board rule that way under that fact pattern. So that's what you want to look at. You have to establish everything you did along the way to notify this claimant that there was no light duty for them, so that they develop the knowledge that it would be unreasonable to think they would still have a job. So in conclusion, I think what you're hearing is that it's a factual issue. It's one that you have to be out in front of at the outset of your petition. If you wait too long, you're never going to have developed the proper facts for your case. It's also something you don't want to leave till the end and show up at a hearing and the claimant says, I didn't look for jobs because I still work for the employer. You know, I have a job. I'm just hurt and I'll be back as soon as I'm better. You need to be aware of it and you need to be prepared to hit it head on at the beginning. I think what you want your defense attorney to be stressing to the board, because you do get a chance in Delaware to give an opening statement, a closing statement like you would in a trial, is to frame the issue of if the court is going to have a broad application of the Hoey defense, it's really contrary to public policy. Does the court want the employer to benefit through terminating employees? Because that's the only way that an employee or employer could stop someone's TTD benefits under this scenario. The person either quits, and their attorney would of course tell them not to quit, or you terminate them, and then you could move forward with the termination. So that cannot be the public policy of the state of Delaware. There has to be limitations on the rule, and the court, through its decisions, has maintained that it is more than just being technically employed. So that's something to hammer home with them. Put it in context, and then bring in your fact witnesses and set up all your facts that you have in your case to your advantage, and that's how you try to get by it. So hopefully that was helpful. The next time you have this relatively narrow issue in Delaware workers' compensation law, but one that comes up fairly frequently, and more so these days than I was seeing initially. And thank you all for attending my webinar, Defeating a Hoey Defense to Obtain a Workers' Obtain a Termination of Benefits in Delaware. And you can learn more about the program and other Weber Gallagher events by visiting our website at www.wglaw.com. Thanks, everyone.